Good morning and welcome to the Deminos GDPR webinar, a guide for managers and HR professionals. I'm Ed McFarlane, Employment Tribunal Litigator at Deminos, welcoming you to this webinar. Now we have a function here where you can raise your hands to confirm that you can hear me, and with that we'll be able to proceed with the webinar. If I can see that anyone out there watching will be able to raise their hands, and then I shall commence with the webinar. I can see some raised hands, so I'll start with that. And welcome to this webinar. So, GDPR, the guide for managers and professionals. What is the GDPR all about? Moving on to the second slide. It's the General Data Protection Regulation, which comes into force on Friday, 25th of May 2018. I'm sure a date quite cemented in our diaries. And along with the repeal of the Data Protection Act 1998, a new Data Protection Act 2018 will come in. The GDPR builds on the old definitions found in Data Protection Act. So a lot of it will be familiar to practitioners, but it has some new ones, and it will remain in force post 29th of March 2019 upon the UK leaving the EU. And there are no plans at all to alter the GDPR at present. The Information Commission has been quite clear about that. And the GDPR fully replaces the existing data protection framework under the current EU Data Protection Directive. And what it means for data processors and data controllers is really a greater emphasis on transparency about your data processing, who you're doing it and why you're doing it, security with penalties and requirements for greater security of data, and also accountability for data controllers. So there are more ways in which you can be held to account for breaches of the GDPR and the data protection regulations. So there's been quite a bit said about quite how onerous this is, and we'll come to that towards the end. But I'd just like to explain a bit of the legal background. Now, the GDPR and the Data Protection Act, what's the difference between them? Well, the Data Protection Act 2018 is currently a bill. It's now going through the House of Commons for its second reading. It's been through the House of Lords already. So from the House of Commons, the second reading is the area, the time when it gets looked at in depth by the House of Commons. It'll go to committee, and then it will come back to the House for its final reading, and it's well on course to become law in good time for the implementation of the GDPR. Now, the GDPR are EU regulations, and they are immediately enforceable in UK law. It is actually the General Data Protection Regulation, but I think most people refer to it as the regulations, and that they can be enforced in UK courts immediately. And what the Data Protection Act does, it provides for ways, if you like, to translate the enforcement of the GDPR and recognition of the GDPR into UK law. And it also covers other areas where EU law doesn't apply, such as national security. So it's helpful to consider the two of them side by side, but for the sake of simplicity, and as the GDPR, if you like, are fixed and coming into force, I'll be referring to the GDPR principally in this webinar. But by all means, we have a fairly good idea of what the Data Protection Act will look like. And if there are any significant changes in it, we obviously will be updating our clients on that. Personal data. This is the key, obviously, to the GDPR. Here's the definition. Any information relating to an identified or identifiable natural person, the data subject, one who can be identified directly or indirectly by reference to an identifier such as a name, an ID number, location data, online identifier, or one or more of these factors, quite a list of factors there. Now, the important thing about this is incredibly broad, and it can cover things such as ID from mobile phones, location data from tracking devices on company vehicles, even personal phones or work phones, and any kind of login that someone might use on a website, for example, on company business, or email addresses. All that can be personal data, and any information you hold, you can be processing personal data about an individual. So it really is incredibly wide, and it covers pretty much everything, all information that you could hold about someone. Now, the basis for data processing, now what the GDPR requires is that if you are a data processor or a data controller, And well, the distinction between them is that a data controller is the one who determines the purposes and means of processing data. And if there's a different person, the data processor is the one who does it on behalf of the controller. They have to have a legal basis for processing personal data. I've taken out here the main basis for processing personal data, which will be set out here. And the first one that springs to mind, obviously, is consent. When it's necessary for the performance of a contract, compliance with legal obligations, necessary to protect data subjects, performance of tasks in the public interest, that's more likely to be something for local authorities and government agencies, and necessary for the data controller's legitimate interests, where there's a balance to be struck with the fundamental rights and freedoms of the data subject. Now, these balancing acts will be a key thing for HR managers and professionals, because there can always be a conflict between what particularly let's say an employee might want and what a manager might want to do. So consent. Now, this is this may be a bit of a paradox with consent, but we'll see now that it would seem to be the most obvious basis for processing personal data, but it's not necessarily so. And consent should be given in a clear affirmative act, establishing a freely given, specific, informed, and unambiguous indication of the data subject's agreement to the processing of personal data relating to him or her. And it sets out various means in which you can do it. Also, it says things like ticking a box when visiting a website rather than having pre-tick boxes, which you still see today. You might sign up for an email and you see pre-tick boxes asking for you to be sent marketing data and that sort of thing. And it's quite specific in to say that pre-ticked boxes or an activity should not constitute consent. So you can't simply rely on the fact that someone has seen your terms and conditions that may scroll into several pages and just said, yeah, whatever, I'll take that. That won't do under the GDPR. And also, when processing has multiple purposes, consent should be given for all of them. This is one of the key things about consent, is that it needs to be informed consent. People need to know what they're agreeing to. They may consent for some purposes, but not for others. Also note, if the data subject's consent is to be given by a request by electronic means, the request must be clear, concise, and not unnecessarily disruptive. I think of those little boxes that used to pop up on websites saying you've won this bingo prize that you never entered into, that flicks around the screen, or sometimes on, say, news websites, the screen goes sort of dark and hazes over most of the text. That's the sort of thing which getting consent that way is really not going to be acceptable under the GDPR. Now, is relying on consent a good idea? I said that the consent may be a bit of a paradox, but really the trouble with, certainly in the HR and employment context, relying on consent is that it's really, it's not yours to control or give. It's the data subject's consent to give. And if the data subject withdraws that consent, you don't have a basis for processing their personal data. So that's why I said that the paradox about it, I think of it almost as a bit like a sort of iceberg, if you like. When you're cool with someone, everything's fine, it's running along well. When things heat up a bit, the iceberg melts away, and that can leave you without consent. You've got no basis for processing personal data, and therefore you're left in deep water. And what you need is something more solid, which is a necessary basis of the other in most employment situations. But like I said, there's a great amount of personal data that employers will process, and you need to think about each particular piece of information and each particular basis for it. So I would say be wary of consent. It's really for the people who are furthest from you. Now, where it may be particularly important is in recruitment, where you haven't got a contract with someone and you haven't got an ongoing relationship with them. You would probably be processing someone's data by consent, but would you have their consent to keep their CV on file if they didn't expressly give it and know you were going to do that if you were running a recruitment exercise and they weren't the successful candidate? But also, what if you're processing their data for the purposes of equal opportunities monitoring? Now, they may not want you to do that, and you may want, as far as you know, to process their data to ensure that you are meeting your equal opportunities objectives by at least monitoring to a certain extent the personal data about individuals. Now, it may be that you can anonymize it and simply break it down, say, by gender and age, for example, or ethnic or national origin, in a way that isn't identifiable identifiable to a particular individual. But if you are processing data from a recruitment exercise for equal opportunity monitoring, you might rely on another basis, such as your legitimate interests, in ensuring that you avoid discrimination in recruitment. So I would say, think of consent as something for the people furthest from you. And when it comes to people who you work for and who you have contracts with, it's more likely that another basis would actually apply to the processing of personal data. Other bases for processing personal data, we have a list of them here. Necessary for the performance of a contract, that's going to be the everyday basis for processing personal data when you're an employer. Necessary for compliance with legal obligations. There's a certain amount of overlap there with performance of a contract. You have legal obligations during an employment contract that you want to follow. Necessary to protect a data subject's vital interests. That's fairly limited, but it can be quite important. Number 4, performance of tasks in the public interest. That's unlikely to be relevant for most employers, but it may sometimes apply. It depends on what sector you're in. And number 5, necessary for the data controller's legitimate interests, where there's a balance between the fundamental rights and freedoms of the data subject. So we'll come to look at these now in particular turn. Necessary for the performance of a contract. Now, this is the basis where notice you're not relying on contractual consent. You're saying, we've got a contract with you, and because we have got a contract with you, that's the basis for us processing personal data. So in order to pay someone, you need to process their data about their working hours, their working time, their rates of pay, their address, their bank account details, and also providing benefits. You may have insurance premiums for health insurance, for example, where someone's age and medical data may need to be processed for that. Keeping track of working hours, you may want to process data about someone's whereabouts and their log on and start times. Keeping holiday records as well. Those are the sort of everyday basis for processing personal data that would be your routine basis for processing personal data, and they will be usually the ones where things will run pretty much fine, because everyone wants to be paid, everyone probably wants their holiday, and everyone wants to make sure that their working hours are correctly logged, unless they're up to no good. Now, necessary for compliance with legal obligations. This is a situation where you may be processing your employees' personal data to comply with your legal obligations, and really whether they like it or not. Perhaps the key ones would be TUPE information. If you are transferring employees to another employee, say you know, for example, there's been a loss of a contract, and you're having to transfer some staff to another employer, you are legally required to provide employee liability information, which can include quite a lot of personal data about people, including their rates of pay, their identities and age and stuff, and also things about their disciplinaries and grievances, which you may have transferred to someone who they're not actually going to end up working for. And that sort of processing of personal data would be done because it's necessary to comply with the legal obligation. Again, providing a written statement of terms and conditions, that's part of the contract, but it also is a legal obligation on the employer to provide that. So again, you can say that you're processing someone's personal data for that reason. And providing information to HMRC, for example, about the earnings someone has, processing someone's deducted income tax and national insurance contributions. There you have a clear basis for saying you're complying with legal obligations by providing that information. And there may be, for example, where you're obliged to provide a reference in the financial sector, or that may be legitimate interests as well, depending on the nature of the obligation. Basis number 3 here, necessary to protect the data subject's vital interest. That might be keeping, for example, next of kin information. You might have people who are being exposed to toxins or hazardous chemicals, and you might want to keep information about, for example, allergies they have, and caring responsibilities as well. So you may process data about someone, and indeed about someone who actually is the other end of the phone, if you like, where that's a legitimate interest. Now, you wouldn't need an employee's next of kin information beyond the day of their last day at work, and that's the sort of data where you'd have no basis for processing anymore once they're no longer employed by you. But you may want to keep payroll data, for example, that you're processing under the legal obligation heading for a longer period of time. So this sort of information will be something where you should have a system where you delete that data pretty promptly when someone leaves, because you no longer got any basis for processing it. Whereas keeping payroll data, you may face a breach of contract claim for 6 years, 5 years in Scotland, and you may face HMRC inquiries for a similar period of time. So you may want to retain data for that sort of period. Necessary for the performance of tasks in the public interest. This sort of thing is something where you may be processing data if you're perhaps a contractor with a local authority. You may need to obtain information to contact residents if there's a particular hazard or something like that. But this is mainly something that would apply to local authorities who are performing tasks in the public interest, and they may need to obtain data about people in a certain area and write to them about something they're doing. This isn't really something that generally crops up in the employment law situation. Moving on to the legitimate interest. Now, this is the most flexible and probably the broadest category that employers will come across. And I would say this is the one that most employers will be focusing on, where they have reasons for processing personal data, which is broader than the performance of a contract, but it's really for protecting your interests. And it can include also things like, they can also be the basis of defending legal claims as well. So there's lots of data you may want to keep under this heading, everything from basic contact details, so you can get in touch with your employees. There may be reasons where you're keeping data such as training records. You want to show that you've trained your staff, that you've been operating a safe system of work. You may need to process sensitive personal data about someone, which is called special category data. For example, looking at an employee's medical record, where there would be a need for you to have access to personal data if they give their consent to it. They don't have to give their consent to it, but if they do, you would want to process that data for your legitimate interests in establishing that someone is, fit for work, and that you're able to make adjustments, for example, for a disabled person. So this is a broad category where generally you can have a right to process data. There is a balance to be struck with the fundamental rights and freedoms of the data subject. So again, you may question, how long do you need to keep training records or a medical report on file for example? Once, say someone's been off on a long-term sick, you may find that the situation has resolved for someone on long-term sick, and would you any longer need to keep that medical report once the employee's back at work and has presumably you've made the adjustments and the condition perhaps has changed. So all these things, different types of data, there will be a basis for processing them. There has to be a basis for processing them, but you need to address as managers what is your basis for processing personal data. So that's the key point here. International processing. Now, certain of our clients may have operations in other member states or outside the EU. One of the things you need to do is consider what is your lead data protection supervisory authority, for example, within the EU. For example, in the UK, it's the ICO, the Information Commissioner's Office. And that's where your main establishment is. So if you are, say, a UK subsidiary of a, for example, a French-owned company, you may find that your lead authority is the French equivalent of the Information Commissioner's Office, and that may be a body that you may have to report to. This may apply where you have cross-border data processing. And again, if you're moving data outside the EU, you need to ensure there's proper legal basis for this and there are appropriate safeguards at the destination for that data. Now, rights under the GDPR, these are the rights of the data subjects. And these are the main ones that would apply. Really, it's the rights of 1 to 7 in this list here, which we'll be going through now. These are the major rights that apply in data processing. So we'll be looking now at the right to be informed of data processing. The data controllers, that's the person who determines the purpose and means of data processing, must convey the identity of the data controller, and the purposes for which information will be processed, and any further information which is necessary in the specific circumstances to enable the processing to be fair. So really, you need to ensure that your policies and, for example, your privacy notices convey to people who you are, why you're processing someone's personal data, and any further information that is necessary for the processing of affairs. So that's quite a broad and vague definition, but it really sets out that clarity and transparency is the key thing, that you need to say to people that why you're processing personal data, and stick to those bases for processing it once you've gathered that personal data. Generally, you would say that in employees, it would be the performance of the contract and management of the workplace, ensuring compliance with health and safety and anti-discrimination legislation, and all the legal obligations that fall on employers. When it comes to any further information which is necessary in the specific circumstances to enable the processing to be fair, this category really, it depends on what you're doing. But if you are, for example, sharing data with another party, you need to let someone know, for example, if you are obtaining data and sharing it with, say, a parent company or something like that, so that people can exercise their rights, such as they have them, to ensure that their data processing is lawful. Because a lot of it is all about the balance that's struck, and that this should become more evident as we go through the basis for data processing. Really, this sort of thing is what you set out in policies. We're updating our clients' policies to ensure that we can say that we can show that they expressly make obvious that where data processing occurs, it's being done for these particular purposes and in line with the particular lawful basis for data processing. Now, the right of access under the GDPR. Data subjects are allowed to have confirmation that their data is being processed. I mean, that's fairly obvious in an employment situation, but you need to inform people that you are processing their personal data. That, particularly in recruitment, you may want to do that. Access to the personal data, so the right to have a copy of the personal data that you process about them. Now, just think about how extensive that could be with someone who's got a work mobile phone, maybe a tracker on their car, lots of emails about them, personnel file, training records, payroll data, clocking in data, location data, and all that. The fee of £10 for data access is to be abolished. Now, this fee of £10, I'm quite used to seeing checks appear from people or solicitors for £10 and pedantic requests being made by employers for that £10, just as a little recompense for the onerous task of gathering personal data. But that's going to be abolished, and the current time limit of 40 days is going down to 1 month. There are circumstances where you can ask for extension if the request is particularly complicated. And there is a right to charge admin costs in some circumstances where repeated requests for a copy of data is made, or if manifestly unfounded or excessive requests are made. So if someone really goes off on one and starts demanding personal data when you've either provided it or have deleted it all, you are entitled to charge admin costs to them. And the Information Commissioner's Office can also charge admin costs for people who contact them and tell them that their data is being wrongly processed. So it's quite like the old right, but obviously there's less time. 1 month is considerably shorter period than the 40 days. So you need to sharpen up your processes to ensure that you can interrogate your systems and locate the data and provide it. The right to rectification. This is another right where, again, this already is a right, but a data subject may apply for inaccurate data you hold to be rectified. Now, think that may sound fairly okay, but there may be a dispute over what is accurate data in an employment context. For example, someone might feel that a statement about them given a disciplinary or a grievance is inaccurate, and it's inaccurate personal data because it's about them, and they may want it to be rectified. And then you may have the situation where you would have to establish whether that data is accurate or not, and refuse to rectify it if you didn't think it was accurate. You have 1 month to respond. You can get an extension of 2 months in some circumstances. And the GDPR says if you're not responding, you must inform the data subject of their right to apply to the Information Commissioner's Office or seek a legal remedy. So you've really got to sort of say, if you're not providing them with a rectification, inform them that they've got the right to seek legal remedy. So you're almost inviting escalation onto your head, but that is how the regulations are. The right to restrict processing. Now, this is the right where someone can say, you hold personal data about me, and I want you to stop processing it, but you're still allowed to retain it. This is often used as a tactic, or I suppose intended to be used as a tactic, to ensure that someone can say, well, I want to see what my data is. I don't want you to process it until I've established, if you like, that it's accurate or inaccurate. And the expectation is that if the accuracy of personal data is disputed, you should restrict the processing until you've verified its accuracy. Now, this could arise in a disciplinary or redundancy exercise where someone disputes their scores. They might dispute their, say, attendance data. They might dispute their performance data in a redundancy exercise, or they might dispute statements about them or evidence, or they might say, I don't want you to process that CCTV that shows me going into the safe, where you're entitled to verify its accuracy. And so there's an obvious balance there, but there are nuances here that could make it very difficult as a tactic where someone has a disciplinary and there is a dispute over the accuracy of the personal data. Now, you then have to make a decision as a data processor whether your processing is necessary for the legitimate interests, for example, running a disciplinary, and whether your legitimate interests override those of the individual. So you would be expected to have a decision maker who says, well, actually, we believe this data is right for us to process it, and that overrides your right to restrict processing. This can also be used where processing is unlawful. If you've unlawfully gathered personal data, for example, you've perhaps overstepped the mark in terms of some snooping on an employee with a privatized. Sometimes these cases crop up where people have been followed by private detectives. Someone might oppose erasure and request restriction of the data instead. And if you disclose data to third parties of someone, and they've said that they want their processing restricted, you should inform them of the fact that this processing data has been restricted, so that they can also act in a similar way. But there may also be a situation where someone may want to have data to establish or defend a legal claim. For example, they may have data about their performance at work, which they say is related to, I don't know, perhaps a car crash or something like that, where they've had a car accident and they're suing for loss of earnings from the other driver. And they may want you to keep that data so they can preserve their rights to defend a claim. So again, this can have a application where it may be, nothing to do with the employer themselves, but it may be that someone wants you to keep data so they can use it, the data subject can use it to protect their own interests, which should be relatively straightforward. The right to erasure. This is another one of the rights of personal data. Where personal data is no longer necessary for the purpose in which it was collected or processed, or where the individual withdraws consent. So again, where someone withdraws consent, the right to erasure arises. So that's why consent is perhaps one of the least useful basis for processing data in most situations. You should erase personal data. It also applies where someone objects to the processing and there's no overriding legitimate interest for the continuing the processing. I mean, this could be out-of-date training records. This could be out-of-date or old training records or old medical reports. It could simply be old pay slips in someone's pay file. And also, there's also a right where a court has ordered personal data to be erased, or that a time limit for keeping data may have expired. So you might no longer need payroll data after 6 years because there's no real possibility of a claim arising from that. Now, the right to erasure should all depends really on whether it's necessary for you to keep that data. And in each case, it may well be that if you properly read your personnel files and data systems, you would find yourselves, going through your contacts and erasing emails of people you no longer use. no longer keeping erasing next of kin data as soon as someone leaves, effectively. So that's another one of the rights that can crop up in an employment situation. The right to object to data processing, someone can object to it. This is often more widely used outside the employment context, but where someone might be using personal data for direct marketing, scientific historical research and statistics. And here, if you do have some data that you're processing, perhaps for marketing purposes, you may find people object to the data processing. And if someone objects because of their own situation, you should stop processing it. This again is somewhere where you may have the right to maintain processing data, for example, to defend legal claims. So you might want someone's personal data because you are establishing, for example, you have not operated a discriminatory recruitment or promotion process, and you may process someone's data to show that persons of a particular, say, gender or national origin or age have been promoted, similar to a person who's complaining about it. And you may be processing someone's data there, regardless of their objections. You may be poring over someone's interview notes or someone's appraisal scorings in a public forum, but that's permissible if you're defending or establishing legal claims. So that's the outline of the GDPR. Now, what are the next steps we suggest you would take? Well, really, you need to identify what personal data you hold about people, where you gather it, and why you gather it. Communicate to people through policies and letters and contracts why you are processing personal data. Make sure that you manage and have processes in place to ensure that personal data is properly stored, securely stored as well, and ensure that everything is in place for there to be a GDPR compliant system. It's quite an onerous system. Then again, most people just get on with their lives and assume that everything's okay. There can be instances of data breaches where you may have to, take steps to compensate people for loss of their personal data, and obviously each case will depend on its own sort of situation. And further on, what steps you should take? Again, we should say that essentially you've got to be quite clear about things. One of the things you may want to do, if you have a significant amount of personal data, designate, not necessarily appoint, but designate a data protection officer as someone who is responsible for the compliance and has really quite a lot of input into the organisation and has the opportunity to address in a corporate situation at board level the issues that data protection arises, that data protection gives rise to. Because I wouldn't say necessarily create a post, but make sure that someone, say HR or finance, has a responsibility for ensuring data protection compliance. Because if there is an issue over data protection and enforcement action is taken, it would be important if you can show you have a data protection officer designated and you've taken steps to implement the GDPR. That would be an important factor in considering whether any action would be taken against you. You want to ensure that you have control measures to prevent, detect and respond to data breaches and infrastructure vulnerabilities. So if your databases are compromised, you need to be able to identify that and report it to the Information Commissioner. Set limits for how long data is stored. So it's not a matter of saying that seems about long enough, but actively ensure that there are limits on how long data is stored, and that is a realistic step in each case. Establish limits on access to data. So ensure also, within the company that data is only processed where necessary for it to do so, and you control the number of people who have access to it. Have a process to respond to and act on data requests and maintain your documentation required to demonstrate that you have actually taken steps to ensure compliance with data protection. If you're doing, there's a mention there of privacy impacts, and if you're doing a major change in data processing, for example, introducing biometric entry controls, if someone enters by a thumbprint, for example, you may be escalating significantly your processing of people's personal data to include biometric data about their thumbs or maybe retina scanning or something like that. That is something where you may have to do a privacy impact assessment where you'd have to basically, like a sort of risk assessment, establish that this escalation of data processing is necessary, and if there are other ways in which the matter could be handled without such a significant increase in privacy impact. Again, this comes down to the fact that just because someone agrees to work for you doesn't mean they agree to, providing their thumbprints or retinal scans or other information as well. Check on the consent given or basis used for processing personal data where you are processing personal data. Just look at your data and ask yourself, why are we processing this data? And ensure that that subject access requests can be dealt with properly. So again, this is things we suggest you do as HR managers and employers. Update employment contracts. Again, you're not asking people to contract into their data processing, but you're actually informing them in a contract, for example, of the basis that the data processing will occur. You may also want them to agree to understand that you have a data protection policy and they have obligations as your employee, because they'd be handling maybe their colleagues or others' personal data, and update your employee handbooks and policies. Just a bit about penalties. Unlawfully disclosing personal data can lead to an unlimited fine. Some breaches, other breaches, it can be unlimited. Recently, a Leicester City Council employee who for some reason was emailing service users details to his own email, he was prosecuted and fined £160. Not a huge amount of money, but importantly, a conviction like that in the care sector, it's going to be career ending. There's no way back really from that. But also, you can be barred from processing data in certain circumstances. Now that's going to be a pretty difficult to run a business if you can't process personal data for certain industries as well. So that would be a knockout blow to certain businesses. And corporations can face fines of 20 million euros or up to 4% of turnover if higher under the GDPR for certain breaches. I mean, we're talking about the mega breaches, things like possibly like the Yahoo hack some years back. So there is teeth behind it, but I would stress that the Information Commissioner is more happy with compliance being demonstrated and people working towards compliance than actually throwing their weight around at the moment. They only have so much resources, and they will be going after, if you like, obvious targets like people who use unlawfully processed cold calling data to ring people up. Those are the sort of corporations I expect would be looked at. But again, large telecoms providers have had data hacks and things like that. They could all be liable under the GDPR for these sort of things. So I hope you found that useful. Now, just moving on now. So look at taking your questions. If you email them in, I'll be responding to them. I may be replying to individual emails or actually respond to certain questions. So I've got some questions coming in, and I'll be responding to them. Got a question coming in from Sophie. For existing employees, do we need to give them the opportunity to consent to us holding the data we already have on them? If so, is there a form or something we need to get everyone to sign? Right, Sophie, on that question, I would say with your existing employees, it's more a matter of informing them, and we've produced letters for some of our clients for that, to informing them that you are processing data and the basis for it. So it's rather than asking them to agree, because, like I said, consent is not really what employment is about, oddly enough, in this situation. It's letting people know that you're processing their personal data, and then they can exercise their rights in an informed way. So rather than getting someone to sign it, I mean, the number of times people won't sign a contract when you give it to them, even at the start of work, because they feel like you're giving them a fiver and taking a 10 away. It's better to declare, if you like, in writing to employees what you're doing and why, and the basis for processing personal data, which generally performance of the contract, legitimate interest, and so on. And we certainly are providing for our clients letters to enable them to inform employees about processing personal data. Sophie also asks, is there a legal limit for how long we can store customers' data? Customers' data, can depend on either consent. If there's perhaps on a mailing list, they probably, contact list, they probably consented to being on that list, but the data you hold will be limited, and they could simply write to you to say, I want you to erase my data, I no longer consent to it. Storing customers' data, though, it depends. If the customers are individuals, they have data rights. Corporations don't. Although an individual at a corporation who is, say, area manager at Acme Engineering Limited, that might be their email address. There might be Northern Area Manager. That could be personal data about an identifiable individual, even if it's, say, an email that doesn't have their name on, because it relates to that individual. So you would store customers' data, really, if you've got an ongoing relationship with customers, I would say you'd be storing their data on the basis of its performance of a contract and your legitimate interests. Certain elements of data may be by consent, so if that person leaves, then you would presumably delete that data, but perhaps inquire, would there be another contact? Linda asks, if we store our employees' personal data on a cloud server and it gets stolen, would we be held responsible? I would probably say yes, because you're the data controller who determines the purposes and means for which the data is stored, and the data processor is the cloud server. You could be held responsible. However, like I said, if you've taken steps to ensure that you use a reputable cloud or provider, and if there were measures in place to deal with and report data breaches, I'd say the likelihood of significant enforcement action would probably be low, because the Information Commissioner's Office do know these things happen, and they may be looking more closely at the cloud provider for not having had sufficient controls in place. Things like the speed at which you reply or inform them. Obviously, you have to know if it's a cloud server and so on. That would be important. But generally, there is a risk with cloud computing. But all the same, it is hopefully they would have top-notch security to enable you to have done everything practical to prevent these things happening. Catherine asks, is there anything we should be sending our employees before May, or just a case of updating contracts, handbooks, and relevant policies? Well, we think it would be helpful to send a letter out just explaining what you're doing for existing employees, and updating contracts, handbooks, and policies as well, simply to explain the basis for which you're processing personal data. A question from Alan. Now that question about data sharing, I think that one is probably best answered off air, and I'll respond to Alan prior to that. I will happily respond to your emails in due course. Karen, do we need to give all employees a data privacy notice? If so, what does this look like? Well, a data privacy notice often is something that you would have on your website. It would depend quite on what data you're processing, but what a data privacy notice really would be, it would be about informing them of the right to be informed, really, is what you need to meet there, Karen. So this is the letter I referred to earlier, where we just a letter goes to clients to explain the basis on which you're processing data. So again, I've covered that earlier. Message from a question from N. We're an SME and our CEO is currently our data protection officer. We don't think we need to want a DPO as per GDPR. As the regs seem to say, a CEO wouldn't be a suitable person. Can we designate a senior individual who is responsible for information governance in the organisation, but not quite in the sense of the GDPR? Well, and yes, if your CEO you think isn't really appropriate, and these things will all depend on the facts in each case, and have a senior individual. Yes, someone who has board level. The Information Commissioner has said, that they would hope that someone who is doing the DPO function, I don't just think it needs to be a special job, but it could be designated, should have influence at board level, so they will be listened to by the board, and the board can act on that. So designating a senior individual who was responsible, but not, if you like, a DPO, that's really, I would say that's probably intending and affecting the protection or compliance that the GDPR are looking for. So that will probably be okay, but obviously it would depend on the circumstance. So yes, I think, N, you're on the right lines. Anissa, Anissa's question is about the controllers to specifically consider the rights and interests of children. If we hold data on children, does it suffice for the parent guardian to give permission to hold data? Yeah, there are special rules on children. Obviously, that's somewhat outside the scope of employment, and I think Anissa will reply individually to your question. But what I would say is, you may have, you may, for example, be be involved in childcare where you have to hold personal data on children. 13 age is the sort of cut-off point where people start to be regarded as having their own rights under the Data Protection Act, and below that, it would normally be parental or guardian consent. And again, the vital interests and legitimate interests would be the basis for processing data for children. Data relating to children is required to have particular care in processing it, because it's important that children's personal data is given special protection by the regulations, and that's something, again, the Data Protection Act is also, which is a moving target at the moment because it hasn't finished through Parliament yet, also has quite a bit to say on that. So we will be able to answer that more fully, but it's really slightly outside the scope of this. Question from Linda about they could get insurance against claims made under the GDPR. Well, if you can insure against the possibility, yeah, I would say I don't know what the risk premium ratio is there, but it's not my. I'm not in a position to advise on insurance, but certainly I imagine there will be providers of insurance who will cover against possible risks, but I suppose they would have their own terms and conditions. Anissa, just clarifying about work experience. Yeah, if you have young people coming in for work experience, who may be 14, 15 or so, 13, 14, 15, or maybe 16 to 18-year-olds, processing their personal data, you would want to ensure that parental consent is given, and also that the personal data you would need on someone that would be pretty much limited to their contact details and vital interests, because they wouldn't be working for you as employees. Charlotte asks, as an HR consultancy firm for SMEs, would each SME have to gain their consent from employees to pass their personal data to us for contracts, etc.? Well, the basis for processing personal data there would be legitimate interests. People need to be informed of the fact that what you're processing their data with, and Charlotte, and the basis in which you're doing it. But if they object to the data processing, you then have a question of legitimate interest. Again, it comes down to consent in employment is paradoxically one of the least flexible basis for processing personal data. And it's more a matter of informing your employees that you're processing personal data in line with your legitimate interests, in providing yourself with HR support, and also possibly for defending legal claims. So if you're taking advice on a situation where you think there may be a disciplinary or a grievance that could give rise to a claim, you have the right to process data to establish and defend legal claims. All those things can apply. But if people say, I don't want you to process my personal data, I don't consent to you processing my personal data for drawing up contracts, we would say, well, we're not processing on the basis of consent, we're processing on the basis of our legitimate interests and for the performance of the contract itself. So it's like the strange split between having a contract with someone and not having their agreement to processing personal data. To a certain extent, what you do there is you use another basis for processing personal data to ensure that your processing of personal data is lawful. And again, there's a balance to be struck between the employee's wish not to have their data processed, but essentially I would say that the processing of personal data there would be one where there is a legal basis for the employer to process that data. So that would be probably be okay. Obviously, it depends. The personal data would have to be the personal data that's necessary for you to draw up a contract. For example, you don't need someone's age necessarily to draw up a contract, but you might need to know their age to ensure that they get the right rate of the living wage if that was applicable to their employment. So I hope that clarifies that. Charlotte, are there any further questions? Right, questions appear to be running low now, so I'd like to thank you for taking part in the webinar. I will be replying individually to questions emailed in, and you can also email in later and we can respond to your questions in due course. And I hope you found that a useful webinar, and we look forward to dealing with your questions in due course.